1 or page 2, written submission. The majority opinion in Rao is flawed on the following counts. 1. Artificially creating a link with the Post-Bribe Act in Parliament. B. Overlooking when the offence is treated as complete under the Prevention of Corruption Act. C. An overbroad interpretation of the phrase in respect of. D. Following the dissenting judgment in Brewster. And E. Making a distinction that permitted a bribe taker to be immune when he speaks or votes in Parliament. Now, on this last point, if I can just address your Lordships, I think we're concerned about how we would interpret that vote or speech in Parliament or the legislature. The interpretation that I give is that it would equally apply to where a vote is not given or a speech is not made, because you could be bribed to do precisely that. If, for example, you go and you abstain and you're paid to abstain, then there is one valuable vote that is lost to the party who would have benefited normally by your vote being given. So it would equally apply. It's a concomitant, just like you've read freedom of expression into Article 19(1)(a) as a concomitant of the right to speech. This is a concomitant, the right not to vote, or where you have not spoken, but if you're going to be arraigned for that, you have to be secured. Now, this in fact is in para 47 of Narasimha Rao, the minority judgment. In the middle of the page, your Lordship, remember the sentence where they said our founding fathers could not have conceived of this kind of situation. So that court also frowns, the minority frowns on this kind of artificial distinction between one who votes and one who doesn't vote. So we commend that minority judgment, Malons, for your Lordship's consideration. Now, if I can take a step back and just mention one thing, and this is there in both the special reference as well as MSM Sharma, the fact that the protections under 105, 194 are protections for the process of the legislature. These are not meant to be immunity protections for individuals who happen to be parliament. That's not the primary object of it. The object is to ensure that the legislative process is unimpeded by any kind of external force. So if a person is intimidated by the fact that I may be hauled up before a court for something slanderous or libelous, that person is deterred from freely expressing his views. For example, in Parliament, if you have to debate on something sensitive, like a minority issue or a caste issue, you may have to go into some sensitive facts. You may have to make statements regarding how people perceive certain issues, and many of them may be objectionable if said in public. But Parliament needs to do that because they are implementing policy via law. So you need to have that freedom. Now, this is not, I repeat, that kind of protection for the individual. It is for the legislative process. It is because the legislative process needs to be unimpeded that the instruments in that legislative process, who are these legislators, are given those immunities. Therefore, it is very clearly linked to the vote or the speech, or as your Lordship sees in 1053, it deals with other aspects apart from speech and voting, for which a law will be made. Until the 44th Amendment, it had adverted to the common law and said what it was in the House of Commons, but now we have said that it will be prior to that amendment. Now, point number 2, the majority opinion in Rao has been doubted by this court on multiple occasions, including by judgments of the Constitution Bench in Raja Rampal and Kalpana Mehta. I've said see para 1 at page 4. So if your Lordships can just see page 4. These are the 3 extracts of which Justice Thakur says in Raja Rampal, while concurring, I may state that I'm not expressing any opinion one way or the other on the criminal trial of such acts, as also the correctness or otherwise of the law laid down in Narasimha Rao. To me, however, there is no doubt, and it is well settled, that in such cases, Parliament has power to take up the matter so far as privileges are concerned, and it can take an appropriate action in accordance with law. If it feels that the case of cash for query was made out and it adversely affected the honesty, integrity, and dignity of the House, it is open to the House to attempt to ensure restoration of faith in one of the pillars of democratic polity. A separate paragraph, Justice Ravindran also makes reference, but then my Lord Justice Chandrachud, as he then was, with Justice Sikri, also said that the correctness of the view in the judgment of the majority does not fall for consideration in the present case, and your lordships have referred to this in the reference order. So far from being a position of law that has been consistently accepted, there have been severe doubts cast on the correctness of the majority. If I can pause for a minute and respond to the other point that Mr. Ramachandran made, which I've seen in the notes that Mr. Mehta has also submitted, that there are previous instances of Mr. Mudgal, then Mr. Subramaniam Swamy, who we're familiar with, and Mrs. Gandhi, Indira Gandhi, all of whom were expelled. And the argument appears to be that, look, Parliament has the power of expulsion. But we have to compare that with what is being argued today. This is about criminal prosecution. Now, if you were permitted criminal prosecution, its full sway, all the consequences that follow would attend that individual. We can't refer to that person as a member, refer to that individual, that accused. That accused would perhaps be convicted by a court of law, would have to face possibly a jail sentence in many of these cases, face a disqualification under Section 8 of the Representation of People Act for a period after his sentence is completed. Compare that with a situation here where your lordships are being told, oh, look, Parliament can expel. In Indira Gandhi's case, she was expelled in 1978. That expulsion was rescinded in 1980 because the House felt, oh, we need her back. Now, that can't be the arbitrary manner in which we leave what is a criminal process to the vagaries of the discipline of Parliament. Parliament will decide separately. That is completely different from a criminal prosecution. Now, point number 3, the well-reasoned minority opinion, on the other hand, has been relied on by constitution benches as well in Kuldeep Nair and Amrinder Singh. Now, these two judgments, the paragraphs, your lordships will find at pages 56 and 58 of this volume. It's not going. Achha. Page 56. Yes. Kuldeep Nair is the second judgment there, my lords. And the relevant portion which is extracted, para 167, if your lordship sees on your screen on the right side, the following observations made in para 47 have been relied upon, and it's extracted. And then this is in arguments. Para 344 is part of their decision making, where the parliamentary democracy being part of the basic structure was reiterated in Narasimha Rao, and they again extract from the minority. So the minority, far from being shunned as if it's some sort of dissent which they shouldn't touch, is in fact considered, not by small benches, but by constitution benches. The same, my lords, follows in Amrinder Singh, which is just lower down at page 58. Next page, please. Yes. If you see the bold portion once again, another comparable instance, the bullet point on the extreme right, another comparable instance was noted by S.C. Agarwal J in his dissenting opinion in Narasimha Rao, and para 25 is extracted. Question of privilege was disallowed since it was considered the conduct of the member, although improper, was not related to the business of the House. Your lordships can come back again to page 2. So the minority is in fact what has been followed by constitution benches and relied upon. 4, the word any employed in articles 105 and 194 ought to be given a narrow interpretation and should not mechanically be interpreted as everything, especially as it grants an exceptional immunity not available to the common woman/man. Now, the reason is that these provisions are dealing with immunity from criminal prosecution. So, far from giving it a wide interpretation, it should be given the narrowest interpretation. Otherwise, the normal criminal law should apply as much to an MP or MLA as it would apply to any man on the street, anybody else, subject to whatever sanctions or other procedural impediments there may be. This is a complete immunity. So you're saying you can't be prosecuted, you can't be held guilty under the law which applies to everybody else. All the more reason that when you give that immunity must be in the narrowest fashion, not the broadest. The majority takes wide interpretations of the phrase in relation to, and does the same with effectively when the word any is used. So it cannot be that if I have taken money for the purposes of a vote, that as long as I've taken that money and I'm walking on my way to parliament, I am a guilty man on the streets of this country. The minute I enter the portals of parliament and I cast a vote, immunity. That is not at all the intention of the law. Now, if your lordship just comes to page 10, bottom of page, sorry, page 4, bottom of page 4. Yes, this we've referred to the state NCT of Delhi versus Union of India. And if you see para 229 at the very top of page 5, when I see the word any in a statute, I immediately know it's unlikely to mean anything in the universe. Any will have a limitation on it depending on the context. When my wife says there isn't any butter, I understand that she's talking about what is in our refrigerator, not worldwide. We look at context over and over in life and in law. Austin, how to do things with words. Now, these are debates from lectures from Harvard University in 1955, but it squarely applies even now. So you can't take something so tenuous and remote and say that we will link it now, it is connected to the vote. Because if that were so, every criminal activity that an MP or an MLA indulges in, he can say, oh, it was meant for the vote. I was just on my way to vote. I ran over somebody on the road, but I was on my way to go and vote. Also, there are some things which slip between gaps and it may come for interpretation at a later stage. Consider a situation where the whip of a particular party is told that, look, we have the whip tells is put under some kind of influence, whatever influence it is. And the whip is then told there's a threat or there's a bribe or whatever, make sure that all these people vote in a particular fashion. Now, that is not technically, the whip's action is not a vote in parliament. The whip's action is not a speech in parliament. Now, could it then be said that the whip, when giving that instruction to his party members, has the immunity? This is a question that could arise. I'm just flagging it because many of these things will fall between two stools. Right now, we are looking at speech and we're looking at voting. But an instruction that goes from a whip to his party members to vote in a particular fashion may not necessarily be treated as one which is immune, because it is not technically a vote in parliament by the whip. It's an instruction that's being given, but it's so inextricably linked to the legislative process that maybe those kind of things will be on the margins. Those are not remote. Those are very close to it. But an illegal act can never be brought in, which is why, as I'll show your lordships later, if you take a broad interpretation of both in relation to and any, which are the words used here, you can bring anything which is remote and connect it to this and claim a cloak of immunity, as long as you keep it proximate, and for which this court needs to perhaps adopt what the majority in Brewster did, which is also something that your lordships have done recently. This is what's the name of this? In Ajit's state of Kerala, Ajit, right? Ajit, K. Ajit. I keep getting the name mixed up. So in similar to what will happen in Ajit's case, and I think there is also a parallel to be drawn. I'll come to that. With the sanction provisions, 197 of the CRPC, 19 in the Prevention of Corruption Act, the intentions are broadly the same. You have to protect people who are carrying out a function. Now, one is a complete immunity. One is another procedural thing where sanction will be given by somebody else. Now, when you are giving that sanction, can you say that, look, it was in the course of my work for me to take bribes, therefore I need to have a sanction? Your lordships have consistently said, and there is a judgment of the federal court, Justice Vaidyalingam's judgment, which everybody else agreed with in the early 40s, which has held the consistent position till today, through the 50s, through that Amroj Singh and all the way up to Prakash Singh Badal, etc., that those activities couldn't possibly have any relation with your public duties, your official duties. So you can't say that I need a 197 sanction for it. It's the same thing which applies here. You can't say that taking a bribe has anything to do with the legislative process.